Another question I have is about the contributory negligence separation. So, well, for starters, could you just kind of point out what that is versus comparative negligence or
Sure.
modified comparative negligence on paper and versus an actual application? You know, how strict is the contributory negligence rule as far as the actual percentages? Could you go into that a little bit?
Sure, and that's another a very important distinction in North Carolina. North Carolina, it may only be the only state right now. I know for a long time it was only 2 states in the entire country that recognize contributory negligence as a defense. And what contributory negligence says, that if the plaintiff was even only 1% at fault in the accident, that claim is barred. They cannot get any recovery for the accident itself. It's a very archaic law. It's unfair to injured parties in an accident. You're only 1% at fault. But in North Carolina, it goes back many, many years, and for some reason they've never changed the law. Most every other state, and South Carolina included, has gone to what we call comparative negligence. That means it will take into account that the plaintiff may have contributed to the accident, and whatever that percentage of contribution is, all that will do is decrease the amount of award that they've gotten. So, for instance, say that the jury awards $100,000 in damages, but determines that the plaintiff was 20% at fault. So that $100,000 would get reduced by 20%, and the plaintiff would only get $80,000. Much fairer to the plaintiff, much fairer to recognizing that sometimes 2 people can cause an accident, but one might be a little bit more at fault.
Right.
But in South Carolina, if they're equally at fault, the plaintiff's not going to recover. So that's a little different. But in North Carolina, if you're just at 1% at fault, it's going to bar you. And that's why even through the course of discovery in North Carolina, we have to carefully look at the nature of the accident and determine, is there a possibility that they can say the plaintiff was, or the injured party was a little bit at fault here, and that may negate the claim entirely.
Right. In actuality, in reality with cases, I mean, it's, there's shades of gray as far as who is at fault for an accident, extenuating circumstances, acts of God, different factors. So it's, in my experience with South Carolina cases, and I'm going to be licensed in North Carolina relatively soon, most likely, it's kind of difficult to really attribute percentages to actual reality and in practice. So